Hello, good evening, everyone. Hi,
Hi, yes, I can hear you. I'm great. How are you?
I'm great too. After work, I decided to connect today from the cute coffee shop. Hello, everyone from Turkey. I'm so excited about today's session. Thank you very much. It's our second webinar with you. I'm so appreciate your time. And we decided to talk about Moon Agreement and Artemis Accord today. So if you want, you may start, introduce yourself, and I will send a message to our group that we are live now. So stage is yours, dear Ridima. Thank you very much.
Thank you. I'll share my screen. So, hi everyone. My name is Ridima, sir, and today I'll be spending some time talking about the legal and historical background of a special article, part of the Moon Agreement, which is the Article 4. And the rough idea is the Article 4 was created on the basis of equity, access, and the common heritage mankind principle. So I'm Ridima, and I am a coordinator and a researcher at the Space Law and Policy Project Group at the Space Generation Advisory Council. And I'm also a member of policy research in the Common Futures Conversation at Chatham House. And I'm also working at the Universal Inclusion, writing about some of the equity issues. So this is very much something I care about personally as well. And I'll share some insights onto this. So let's begin with the core legal principles. So the excerpt I have here is actually the direct clause of the Moon Agreement. So there are two parts of it. The first part basically explored that how the exploration and activities on the moon and the use of the moon will be in the province of all mankind and shall be carried out in a manner that benefits everyone and in interest of all countries, irrespective of economic and scientific development. This is the main clause. That is the core legal principle, pretty much also dictating what Moon Agreement as a collective also stands for. And this is what Article 4 focuses on. And the due regard is also taken in as a second consideration of this article, which means that the interest will be present for both present and future generations, meaning there is also concerns for the current activities that are occurring in the moon, but also for future generations. So this is also as a legal governance framework for future generations and concerns of how they would be able to approach the moon. And it covers universal domain, it covers the benefits of all states, and it also has the no exclusion principle. When we look at what this intends to do, why does it exist? A very simple fact, simple four domains come into this. And first is that it aims to ensure that lunar benefits are not just independent, not just focused for a few states or technologically capable states or developed states. So this was also the major concern during the Cold War. So during the 70s and 80s, this was a major concern, and it still remains very relevant today because I've entered the governance picture. Beyond this, there is also the second factor, which is the equitable access. Ultimately, equitable outcomes is not necessarily exactly what it intended, but equal opportunity to moon, which means any kind of operation, any kind of resource related activities, all would be given in a fair, opportunal access. Beyond that, transparency and cooperation, which is also to promote openness and collaborative conduct in on the moon. So for any activity that is being done on the moon, it would aim for having a very fair approach to lunar activities and space activities. So there is a sort of trust building and peace on moon. And the final thing is intergenerational stewardship, which is again very specifically written in the clause so that we don't look at moon just as a current astronomical object of exploitation, but as also an object that future generations can enjoy and take their time exploring. So we're also taking the responsibility right now for what happens to future generations who are going to the moon. So this is what basically the Article 4 intended when it was drafted. But how was it shaped? It's very important to understand this because the shaping of the Article 4 was extremely political and also very nuanced, and there were multiple layers as to how the Article 4 and the collective Moon Agreement came to existence. And this entirety of the Article 4 basically got created, and the entirety of the Moon Agreement basically was shaped during the 1970s. So from 1971 to 1973, developing nations, particularly India, Egypt, Chile, they strongly advocated for equity-based governance. So they wanted to prevent the moon from becoming a site of just resource monopolization. Oftentimes, something that we see here on Earth as well, resources are very much competed over and creates a lot of geopolitical tensions as well. So they did not want that to happen on the moon. They did not want the moon to be exploited for its resources. And they also didn't want it to become a hub for only major superpowers. But of course, during the mid 70s, 74 to 76 specifically, the major space powers, which again include US, China, and Russia. At that moment, US and Russia were the top contenders during the 70s, but they pushed back for a more flexible and non-binding interpretations. Now, what this means is that they were concerned about the restrictions that would happen for the Article 4 principle on commercial today, because Article 4, as beautiful as it is on its equity purposes, it is a little ambiguous on the specifics, on the technical aspects, which meant that ultimately the Article 4 wasn't covering all of the governance requirements that would come up when we are looking at the technical developments we have on Moon right now. And then by 1977 and 1978, we saw the Common Heritage of Mankind, which was recognized. But again, like I mentioned, the major pushback that happened during the 74 to 76 period sort of avoided the operational details to be really enforced on the clause, which is why the operational details don't exist in the Article 4. And finally, in 1979, we saw the final text being adopted and being part of the entire Moon Agreement, which was signed by the UNOSA and the United Nations. And again, it is not just henceforth idealistic. This was very much created by nations and created by actors at that point of time to create a product so that competing visions come together for equity and access. And again, this was negotiated for nearly a decade before it was put into an international treaty. So this is how the Article 4 came to shape today. And again, like any legal is its fair shares of strengths and limitations. And the Article 4 is not exempt from it either. So some of and articles in the international space law community that actually establish a universal fairness, and it also establishes a baseline of equitable fairness for all lunar activities. So anything that's done on Moon, having an equitable approach and a fair approach is now solidified in law. And it also protects against territorial fragmentation and appropriation, and it also encourages cooperative scientific access, very important. And also, again, like I mentioned, intergenerational responsibility. But the limitations are a little more concerning and I think take more traction in the current generation. There is no enforcement mechanism, something we see oftentimes in international space laws. And also the language for resource extraction, which is probably the most debated topic in space law and will be in the coming generations as well. There is the resource extraction language is very ambiguous and there's no clarity on how far or what can be exploited or not exploited or what is considered territorial or not territorial. And beyond this, it also lacks ratification. And this is a very important point because it's not ratified by any major spacefaring power or any leading emerging space nation, which means many countries have not adopted domestic space laws following or adapting the Moon Agreement, which means no country is technically bound to this specific agreement, and very few countries, including Australia, that have actually signed the Moon Agreement to be ratified into their domestic laws, meaning most of the major leading countries don't really align with this specific article or this collective agreement. And beyond that, the Article 4 and the Moon Agreement collectively expects and anticipates a future international regime which is neutral, which is fair, which currently, even with the existence of international platforms, does not exist at the moment. So we have the common heritage mankind in law. Is it operationalized? No, and that is one of the biggest limitations. Beyond this, it also is important to consider the equity lens, since this is the main implication of what the Article 4 came to existence for. And that is that it's very important what its intention is, regardless of how well it can be adapted or how well it can be followed or how well countries approach it. Ultimately, the principles and the values that the Article 4 stands for is incredibly, incredibly important in our new generation of moon exploration. And some of the main ideas of these principles and morality, let's say, on the Article 4 includes the developing nations perspective, which is that the article was a deliberate intervention against capability-based entitlement, meaning to be involved with these missions to the moon can get a fair opportunity and fair access to collaboration, and also developing nations were part of the legal architecture of designing these mechanisms for this law. And ultimately, the Article 4 sort of challenges the assumption that the moon, who gets to the moon first, will control its resources or sets it rule. Although we see that it's not inherently compatible with the realities we're living with right now, the principle is very much in serving for all of humanity. Beyond this, ultimately, while we talked a lot about principle and we talked a lot about the ideas that the Article 4 was intended for, having a law implemented, having a law enforced, and having a law really change behaviors and mechanisms is something that we still see is very much failing, especially when we see the implementation of Article 4. And while it does provide the principle of universal benefit, we see in our modern era of lunar operations, the ethical mechanisms oftentimes oversee the principles and fairness mechanisms. So we need to have a balance between principles and practice and make sure that we can avoid harmful interference and actually have equitable outcomes when we go to the moon and we see operations take place, which will happen very soon. So the central challenge that I would say that we can take away, while Article 4 is amazing in what value it embodies, we need to make sure that it can actually have operational tools, which are currently lacking, to uphold its principle without creating exclusivity, and also sort of preserve the multilateral spirit that the Article 4 and the Moon Agreement, alongside the Outer Space Treaty, hope to achieve for the lunar reality and lunar activities we're living in. So that is all from my side for today. So we can keep the conversation going on this. You can find me here, but I will hand over to Maral, who's going to talk about the other framework that sort of completes the modern day picture of lunar operations.
Thank you very much. Thank you very much once again. I'm going to share my screen and we're going to continue to discuss this topic together. Today, I wanted to do some interactive presentation. So just one. So today I wanted to do some interactive presentation and critical thinking. So my main title of my presentation today is Today I Got Questions, because it's going to be about sharing my questions. The Socrates, maybe you heard his approach, Socrates method. I will use it. So we said that Moon Agreement, Article 4, and I wanted to capture this. The exploration and use of the moon shall be the province of all mankind and shall be carried out for the benefit and in the interest of all countries, irrespective of their degree of economic or scientific development. So here I got a lot of questions. So let's discover it together. How many states have independently conducted lunar missions nowadays? Which countries currently possess the technological and financial capacity to access the moon? Does the concentration of lunar activities among a limited number of states challenge the principle of equitably benefit sharing? What scientific, technological, economic, or educational benefits generated by lunar missions are accessible to developing countries? Are existing mechanisms sufficient to ensure that all nations benefit from lunar exploration regardless of their level of development? These are the questions. When I read this article, these questions are first they came into my mind. So let's continue. If you got internet, you may write a moon agreement and as well open it and continue to read with me. So due regard shall be paid to the interest of present and future generation. This is the most interesting part. So how the rocket launches affect atmospheric composition, biodiversity, and Earth's ecosystem? So should environmental sustainability become a more prominent component of space governance? How can lunar activities be conducted without compromising future opportunities for scientific research and exploration? In a world experiencing declining birth rates in many regions, for example, in Turkey nowadays, the people don't get married, don't get, how can I say, don't give a birth. So when we look at the future, will we have this diversity in all nations, or it will be more like from the some specific regions? So the need to promote higher standards of living and conditions of economic and social progress and development in accordance with Charter of the United Nations. So do nowadays, let's think, do all individuals enjoy equal access to education, employment, scientific participation, and fundamental human rights? When we look globally, when we look at each country, I don't think we can say yes. I mean, not only on the paper, but in a practice. Do indicators such as GDP, minimum wage, adequately reflect human well-being and quality of life? Can lunar exploration contribute to reducing global inequalities, or does it risk reinforcing them? And they said now, should the international community pursue a more comprehensive and inclusive mechanism under the United Nations to coordinate lunar exploration? How can such a framework balance national interests with the principle that moon is the common concern of humanity? So more than 4 decades after the Moon Agreement entered into force, Article 4 continues to raise fundamental question. Can humanity transform the ideal of the moon as the province of all mankind from legal aspiration into a practical reality, as dear Ridima highlighted? We got a really good theory, but in practice, we have to do it right. The answer may depend on whether future lunar activities prioritize inclusivity, sustainability, human rights, and international cooperation. So when we look at the Artemis Accord, Section 11, we see that there's a mention about safety zones. And what is this? Simply the existence of safety zones, the confliction provisions raises a fundamental governance question. Are the primary challenges of future lunar exploration rooted in the hostile natural environment of space. Like, in a previous webinar, we talked about space debris and they are highly speeded and they may cause, for example, um, uh, collapse. This is a danger in space. And also we got, a lot of radiation in space, but uh, or we create the safety zones to increasing complexity of human activities beyond Earth? The answer may significantly shape the future legal and political architecture of lunar governance. So when we look at Artemis Accord Section 11, we see that again, if safety and deconfliction measures are intended to protect space actors from unknown extraterrestrial entities, for example, an obvious question arises, will such entities be aware of or bound by the legal norms developed by humanity? So, but in another way, if we, however, these measures are primarily intended to protect states and operators from one another, and more fundamental questions emerge. How we fully understand and embrace the spirit of the Outer Space Treaty and its vision of outer space as a domain of peaceful cooperation for the benefit for all humankind. In other words, are the greatest risks to future space exploration external to humanity or do they originate from humanity itself? So here you see a lot of questions. I'm going to share my presentation. I think our presentation will end soon. We have 1 minute left, but I will try to keep it quickly. So as you see, I got a lot of questions and most of them I know answer, but I want to know your opinion and maybe my answers are wrong. We will discuss it together. And I think in a future webinars, we will open this topic because it's not only about us, it's about our future generation also. And we have to act wisely. So thank you very much for participating in today's section. It was my pleasure. Thank you very much. So dear participants, if you have any questions, you may chat us, on WhatsApp chat group. We have nearly 40 people and it's a great pleasure. It shows that we do something great, Ridima, and I hope we will continue to do such a session. Thank you very much. Love you all. Bye bye.